and welcome to Green Spoon Martyr's Cannabis Quick Hits series. I'm Nick Richards with everything you need to know in the cannabis industry. Today I've got Mike Freeman with me, my partner. Mike, is that you?
That is me, Nick. Good to see you.
Mike, I'm getting some pop-up here on my webinar browser, and it's asking me questions, and I went ahead and answered them. I hope that's all good. But we're going to keep on going here. Mike, you are a labor and employment lawyer. Is that right?
That is correct, among other things, but that is definitely one of my areas of expertise.
And I know you do a lot of litigation as well.
True, I do.
It's interesting. Maybe you have to be a bit of a litigator to kind of understand and have good perspective around employment issues as they come up prior to litigation, I would bet.
That is a good point. Yeah, I think if you're able to litigate, then it's easier to advise clients on things not to do or to do to avoid litigation, because no client ever really wants to find themselves in a courtroom situation.
I get that. So Mike, tell me, you know what? I'm an employer. I'm a tough guy employer. I do it all myself. What do I need some labor lawyer for?
Well, you look like a tough guy employer, but I think nobody really wants to call a labor and employment attorney. Usually when a lot of times if I'm on the call or if I'm making the call, employers get a little uneasy and will move in their chair as to why is this guy calling me? But I think if employers and companies are being prudent and cost and time efficient, they'll reach out to a labor and employment attorney in two primary situations. And I'll kind of give you like a big broad brush of examples. Number one is when they're doing an investigation in-house and they want to make sure that the investigation is covered under attorney-client privilege. And in order for that to happen, you need to have an attorney on the other side where the investigation is being done at the attorney's request, and whether that's somebody in-house or externally doing the investigation. That's one reason why you want to do it, just in case something comes up that may not be completely advantageous to the company, or you may not want to disclose it as part of the discovery process. You can say that the information is covered under attorney-client privilege, and that's just a smart, proactive, protective way of making sure that you have at least that tool to use to the extent that you need it. Number two, which I think is a little more widely used or expansive, would be I have a situation that I feel a little bit uncomfortable about. The hairs on the back of my neck are sticking up a little bit. I have a termination, or I have an employee disciplinary issue that I'm not 100% sure what to do. I think I have a good idea, but would love to run it by somebody who's been there, done that, just to soundboard or spitball ideas. And I'm a big advocate of spending the 5 to 10 minutes of let's talk about what your strategy is. Here are some pitfalls that I've seen. Here are some things that I would recommend you do, as opposed to getting the phone call afterwards and a client telling me, here's what I did, help me fix it. The 5 to 10 minute call at the front end will save a lot of time and money of trying to fix it on the back end, where you're spending hours and hours trying to undo a situation that could have easily been avoided.
And Mike, you and I talked earlier about things like employment manuals and things of that sort. And I suppose that if you've engaged as a business owner with a labor, or a business manager with a labor attorney, you might have some best practices in place already for when certain things might come up. And maybe you've already had a talk with a lawyer in that early stage. Seems to me like there's a couple. What you sort of set out is, the first one you mentioned was an investigation. I guess an investigation would happen as a result of a situation that is of a heightened concern of some sort. And so really, that you not only want to call your lawyer at the start of that investigation when the incident first arises, but then having the lawyer involved in the investigation itself then cloaks it with attorney-client privilege. Is that my understanding?
That's correct. So the lawyer can serve in a couple different roles, or a couple different capacity. Number one is helping be part of the investigation, whether they're actually investigating or communicating with HR or whoever is conducting the investigation as some type of, we talked about, sounding board, or here's what we're doing, and have somebody report back into the attorney to give them updates as to, here's how this interview went, based on the findings of this particular interview. This is my plan for the next person, or this is who I think I should talk to next, or here's the document that we just found. What do you think about this? So I think that's probably a key component. And then just being able to have the employment counsel to run the findings by. So at the conclusion of the investigation, here's where we are. What do we do with this information? Help me understand and unpack all of this data and interviews and information that we uncovered as part of the investigation. What do we do with it all? What's the best practice? How do we move forward with this to keep our risk and our potential exposure to an absolute minimum?
And I would imagine that a big part of keeping that exposure to a minimum is creating a record around doing the investigation itself. Isn't that part of an employer's duty? And so then documenting that the employer satisfied that duty, I would think, would be a big important part.
It's key. It's a great point. And you want to be able to document that you had the investigation. So first of all, the investigation itself, you are cloaking it under attorney-client privilege. I would say 95% of the time, if not more, you're going to waive that privilege in order to show the court or opposing counsel that you didn't sweep this incident under the rug, and you did conduct a thorough and complete investigation. And as part of that thorough and complete investigation, you're going to want to be able to produce some type of written document to show what you did. So whether that's a 100 to 200 page report that the investigator submitted or put together, or a lot of times what I like to help the investigator or company prepare is an executive summary. So it's more of a condensed, succinct version of the report that lists at a high level what the issues were, who the investigator spoke to, and the findings, and possibly a recommendation. And that's another key point too, is at the conclusion, or I should say at the beginning of the investigation, we should get an idea from the company as to whether or not the investigator is making a recommendation as to what to do at the end of it. And sometimes investigators, without having that guidance, will put that out there. But you want to have that conversation before the report is done, so the investigator is not put in a weird situation as to, well, are you going to give us a recommendation? Or, hey, why did you give us that recommendation? We never asked for that, and now you're putting us in a tough spot.
Mm-hmm. Interesting. And so and I assume that this investigation then also has to be done in some very specific ways. Tell me what kind of areas does these things come up in? I could see that there could be there's a fight or something that occurs, or there's some harassment of some sort, or what are the areas? If I'm an employer, what should be setting off the bells in my head? Aha, this is not normal day to day. I need to call my lawyer. We're going to need to take certain steps now. What triggers my thinking there?
Yeah, good question. And I think the term investigation is pretty general, and I think it could include having 10 different people interviewed and doing a pretty comprehensive review of emails and documents. Or on the other end of the spectrum, it could be, I'm going to talk to the complainant and see what he or she is alleging, and then after I'm done with that particular interview, talk to the alleged wrongdoer and get his or her side of things. And so it could be as simple as that. But to answer your other question, I think I've seen this in the sexual harassment, Me Too world, where you want to make sure that you are looking into any sort of allegations that would cross into that space, theft, or those are things that if there is a pretty deep, you have a concern with somebody who has access to company information, and they're digging into things that they should not be digging into, whether it's proprietary or confidential. You may want to do an investigation to that. If there's a fight going on, yeah, you probably want to find out what happened or why it happened. But that's probably, unless it's something that's leading up to that fight, that's probably a lesser involved type of investigation, and not something that would take as much time as something that's more complex.
Mike, in my world, in the tax world, when there's theft in the workplace, oftentimes it has to do with employment taxes that are stolen. When salaries or withholding is taken from salaries, companies have to hold that money and then pay it over to the IRS, and it's kind of an area of business that gets pushed down the road a lot, and things like that. So it's an area that oftentimes bookkeepers will, unscrupulous employees and folks like that are, those classic folks that are in a position to steal, will take those funds. Which I know that's sort of my area, not your area, but I would imagine that you see that as well. Okay, so I've got fighting, maybe a little bit lesser, harassment, theft. Mike, so I did a panel a little while ago, a similar quick hits with Carol, our partner out of New York, on drug testing. Is that also an area where you'd want to talk to your labor lawyer and pull them in if you had an employee that was in? I think Carol made it clear that the concern is where they are in a hazardous workplace, and that there's a positive drug test. What is that, the similar kind of an area of concern there?
Yeah, it is. And I think it's going to depend on, once again, your earlier point, do you have a policy on drug use in the workplace, on drug testing? At what point in time is it appropriate to do drug testing, whether that's pre-employment, whether that is post-accident, and that's when you're doing the drug test. But you should be following your policy there. Whether the policy says you could drug test upon reasonable suspicion, is that clearly defined? So I definitely have a lot of conversations with clients as to, hey, we think somebody came into work today, they're drunk or stoned or under the influence of something. Can we test them? And that's maybe a little bit nuanced or different than the topic you talked about with Carol, but it's something that I deal with a lot of times. And it's a conversation of, well, what is he experiencing? Do you have a written report from the person who observed the individual? What does your policy say? Have you defined reasonable suspicion? Or does that word even appear in your employment handbook? Things like that. And then what have you done in the past? And you want to be able to treat this person similarly as you have other people that have experienced or showed the same type of signs or symptoms.
If you had a policy around these things, would there also be a policy? I mean, obviously if you're going to subject your employees to drug testing, that needs to be a policy. There needs to be a policy and a method to do all that kind of stuff. Is there also, would there be a policy about how to handle situations like harassment, et cetera, when they come up? Is that also part of a policy that you have in place?
Absolutely. And you want to have that in your handbook. That's a big foot stomper of making sure you have in your policy what happens. We're a company that does not allow or permit any sort of harassment or discrimination. You want to make sure you have that in your policies. And if you do become aware of harassment or discrimination or any mistreatment, these are the steps you should take, whether it's going to HR, whether it's going to your supervisor, if you have an anonymous hotline that the company has set up. Laying all that out would not only hopefully deter any sort of that bad behavior, but to the extent that you're ever sued or an action is brought against you, you can show the court or the jury that you take these proactive steps to try to minimize or eliminate any of that type of behavior. And you as a company should not be held accountable for one person's bad actions.
Now, Mike, super good stuff. I'm thinking there's kind of, you sort of teed this up in a way of employer is suspicious of something, calls their lawyer, tries to figure out the way forward. I guess the other way that this would come up is an actual employee makes a complaint of some sort. I'll bet you get calls where employers have received a complaint and now they need to know what to do. Is that different now if an employee is actually making a complaint than when an employer is suspicious?
It is. It should trigger certain requirements on the employer side, but if the employee is making a complaint that they've been mistreated, or if there's something happened in the workplace that they at least have flagged for you, the employer at that point is on notice. And there should be at least a conversation or proactive steps that they need to take in order to make sure that they're addressing the situation, and the employee can't come back and say, hey, I complained to HR, my supervisor, the hotline, and you guys did absolutely nothing to deal with this. So at that point, I strongly recommend that if they don't have a policy or practice in place, reach out to your labor and employment counsel, have those, what could be a very short, sweet conversation about next steps, and get that strategy or that timeline laid out of here is what I think we should do on a going forward basis and how to minimize the potential risk or exposure that they have.
Mike, thanks so much for that great information. One last thing, I'll bet that there are different requirements depending upon the different states that folks are operating from. Does state law play a big role in this?
It does. I mean, you're looking at each state has their own laws. A lot of them mimic the federal laws, but you certainly want to know what your state law requirements are, what the reporting requirements are, the timelines. All those could differ from state to state. So yeah, it's definitely important to reach out and know what the requirements are. Mike,
tell us how we can get a hold of you.
You can get a hold of me at, I'm sure we're going to put it up on the screen at this point, but here's your email, phone number. I respond to all those things. So reach out to me and I will get back to you as quickly as possible. But thanks for doing this. And it's been great chatting with you.
Yeah, Mike, thanks so much. And as our viewers know, Green Spoon Martyr, we practice law in every state, so we can help you wherever you are. And we're ready to take your questions and support you as needed. Thanks so much, Mike. Thank you for joining us today. And shout out to Carol in the prior video quick hit that we did, which you can get at gmlaw.com, along with all of our other quick hit videos. Thank you so much, Mike. Have a good day.
Thanks, guys. See ya.